Mr. Vijay Hansaria, Senior Senior my colleagues, members of the registry, ladies and gentlemen present here today. I welcome you all today to the knowledge to be delivered by Reverend Senior Advocate Mr. Vijay Hansaria on Electoral Ergonomics and Judicial Intervention. It's quite a new topic for us, and I'm sure we have a lot to learn from this lecture today. Mr. Vijay Hansaria has the distinction of being the first advocate from this part of the country to be designated as senior advocate by the Supreme Court. We are indeed very privileged to have you here, sir, today. Mr. Hansaria has over 4 decades of practice in the Supreme Court, and he is a local from Assam, from in fact Roha, Roha district. He took his graduation in economics from JP College, Jorhat, and thereafter he did his graduation in law from JP Law College in Guwahati in 1980. In the same year, he enrolled in the bar, and thereafter he has been practicing in the Supreme Court. He needs no introduction so far as senior members of the bar are concerned. However, from the younger lot, I would say that this is an opportunity which we should seize, and we request him to come over again with a different topic, an interesting topic, and enlighten us. He has been an advocate on record since 1985 and started a law firm by the name of Hansaria and Company, and was county counsel for the state of Assam, and also appeared for the Guwahati High Court for a long period of more than 30 years. He was elected as the Vice President of the Supreme Court Bar Association in 2004. He was also appointed as a member of the NALSA for the period 2013, 2015, and again 2019 and 2021. Son of illustrious father, late Justice B.L. Hansaria, the judge of the Guwahati High Court and retired judge of the Supreme Court. He had revised the books of his father on the jurisdiction and 6th schedule to the Constitution of India. And in fact, late Justice B.L. Hansaria is an authority. I would say we always refer to his books when the question of 6th schedule comes in. He has also authored books like Chronicles of Indian Constitution and Working Manual on Juvenile Justice Act. Mr. Hansaria has been appointed as a advisor in various important acts by the Honorable Supreme Court, which are like the Martial Law relating to the detention of mentally disabled persons, Malik Mazhar Sultan pertaining to monitoring and filling up of vacancies in subordinate judiciary, Ashwini Kumar Upadhyay for expeditious trial of criminal cases against MPs and MLAs, and we all know these matters are being taken up at the attention of the Honorable Chief Justice of the different high courts. Now, without delaying the proceedings. Without delaying the proceedings, may I call upon the Secretary, Indian Law Institute, Mr. Tanmay Mahanta, Senior Advocate, to felicitate our guest speaker, Mr. Vijay Hansaria, Senior Advocate, with a Ramucha, a Salai Sara, and a bouquet. May I now request Senior Advocate Mr. Renat Chaudhary sir to felicitate the Honorable Chief Justice Maharashtra High Court with a Ramucha. Now I call upon the Executive Chairman, Indian Law Institute, Assam, Honorable Justice Mr. Soumitra Saikia, to speak a few words on the Indian Law Institute and its activities.
Honorable Mr. Justice Rashmin Anandramai China, Honorable Chief Justice of the Guwahati High Court and President of the Indian Law Institute Assam Unit. Respected Honorable brothers and sisters on the bench, Sri Vijay Hansaria, Senior Vijay, as Speaker of today's program, respected senior counsels, members of the Guwahati High Court Bar Association, members of the Guwahati High Court Advocates Association, members of the registry, my dear students, ladies and gentlemen, very good evening to all of you. It is with great pleasure that I take this opportunity to welcome you all to today's evening's law lecture organized by the Indian Law Institute, Assam Unit. Mr. Vijay Hansaria, Senior Advocate, Supreme Court of India, has been kindly consented to deliver a lecture on the topic Electoral Ergonomics and Judicial Intervention. I take this opportunity to welcome you all on behalf of Indian Law Institute, Assam Unit, its office bearers, and executive members. The Indian Law Institute was founded in the year 1956, primarily with the object of promoting and conducting legal research. The Institute is an autonomous body registered under the Society Registration Act, but it has requisite independence and academic freedom to carry out its objectives. The ILI runs various programs in the field of law, including undergraduate, postgraduate, doctoral programs, several certificate and diploma courses in various branches of law, which are conducted both online and offline. The Indian Law Institute has several state units and chapters across the various states which have been established over the years. Insofar as the Northeast is concerned, the Assam State Unit of the Indian Law Institute was set up and was accorded recognition by the Chief Justice of India and the President of Indian Law Institution, Honorable Mr. Justice Vijay, as his lordship was in the year 2006. The Assam unit of the Indian Law Institute was set up with Honorable Mr. Justice B. Ferguson, the Chief Justice of Guwahati High Court, as his lordship then was, as the President, Honorable Mr. Justice Ranjan Gogoi, former Chief Justice of India, as his lordship then was, as the Chief Executive Chairman, Honorable Mr. Justice Rishikesh Roy, Judge, Supreme Court of India, as the Secretary, as he then was, and Mr. Ashwin Sharma, Senior Advocate, as the Treasurer. Since its inception, several symposiums, training programs, workshops have been undertaken by the Indian Law Institute Assam unit, except for the brief period of the COVID-19 global pandemic. In continuation with its aims and objectives, the Indian Law Institute Assam unit, under the leadership of our respected Honorable Chief Justice, Honorable Mr. Justice Vijay, as the President of India, the President of Indian Law Institute Assam unit, we have undertaken to organize this law lecture on electoral ergonomics and judicial intervention by guest speaker, Mr. Vijay Hansaria, Senior Advocate, Supreme Court of India. I am very optimistic that the Indian Law Institute Assam unit shall organize many more such symposiums, law lectures, workshops in the coming months. I eagerly look forward to the lecture to be delivered by the guest speaker this evening. I am certain of all the continued guidance and support of all the dignitaries present today in all future events which are likely to be held by the Assam unit of Indian Law Institute. Thank you. Namaskar.
Now, may I call upon the Chief Justice, Bharatiya High Court, who is also the President of Indian Law Institute, Assam unit, that will be present.
Esteemed brother, Justice President, Vijay, I will ask something. Esteemed brother and sister, judges, Mr. Vijay, Vice Chancellor of Law University, Mr. Vijay Hansaria, the Senior Advocate, Supreme Court of India, and Speaker of the Day, the Senior Advocate, members of the bar, dear students. The eminent jurist has described life of an advocate in one sentence. He used to tell us that life of an advocate boils down three words. One is tension, then mention, and then attention. He used to tell us that when you receive the list, you are put in tension that what will I do tomorrow? Then at 10:30 you mention and get little relief, and then you give attention to the matters which are to be attended. According to my opinion, ILA is an institution which takes an advocate and judges away from those three points. And as rightly used in the Ergo 5 ILA, it is an attempt to bring the element of Tamasoma and Jyotirgamaya. And we are fortunate here today that Mr. Vijay Hansaria will take us from Tamasoma and Jyotirgamaya on a subject which I have to, frankly speaking, refer to dictionary that what is there. The Indian Law Institute Assam chapter was a dormant because of COVID. With the help and enthusiasm shown by my brother Justice Vijay and the learned seniors who are members of the executive committee now, we have been able to see this space. It takes me immense pleasure to inform this august gathering that ILA Assam chapter is planning to organize various seminars and law lectures by inviting eager luminaries like Mr. Hansaria, from across the country, both virtual and physical. Today's topic is just a kickstart to get the ball rolling for many such events which are likely to be hosted by Assam chapter in days to come. I hope and trust that this type of lectures shall continue to be in form of a series, and I honestly urge all my brothers and sisters to help us in that endeavor. I don't want to come in between all of us and Mr. Vijay and Hansaria. I express my gratitude for giving me an opportunity to become part of the occasion in which I highly Assam chapter a great success. Thank you very much.
Before starting the lecture on the stage, the speaker would like to present a few books. Firstly, the Chronicles of the Indian Constitution. To the Honorable Chief Justice. Yeah, another book to be present to the Honorable Chief Justice of India, that is Criminality. May I request the Commissioner to kindly forward on office on the same book to be presented to the bar. Mr. Vijay, the President of the bar. Now we are request our esteemed guest speaker to deliver his lecture on electoral ergonomics and judicial intervention. So please.
I'm feeling like talking to your cortex. In the economic value, so sorry, I can't stop myself. It's my problem. Because sir, we have over 100 certificates and information. Assam, we work from Guwahati in Supreme Court. Whenever we speak in Assam, if anyone speaking anything else in Assam, I really want. So that's what you deserve, which I will do it. Honorable Chief Justice, President of the INI Assam Unit, Assam Branch, Honorable Justice Director, Executive Chairman of the Assam Branch of ILI, Honorable Judges, the Guwahati High Court, whom I respect too much than any other High Court judge, Mr. Tanmay Manandra, Secretary of the RI Assam Branch, Mr. Minal Chaudhary and other executive members of the High Assam. Mr. Dilip Chaudhary, President of the Guwahati High Court Bar Association. Mr. Dr. Vijay, Vice Chancellor of the National University of Guwahati. Dr. Vimal Osho, Professor and Faculty, Head of the Faculty of Juridical Sciences of Sanskrit Vishwavidyanaya. My esteemed colleagues, friends, ladies and gentlemen. It's indeed a great privilege, and I say from bottom of my heart, that I stand before you to deliver a talk. I've never thought 40 years back, 42 years back, I'll be saying here, I am almost sitting there circle. I'm extremely grateful to the extreme cooperation, whatever I am today, whatever little I have seen today, because of the cooperation of the senior members of the bar before them, other members of the bar who will give love and affection, who will post confidence in me. I could grow only because of your support. And again, it's a privilege for me to stand before you, before the Honorable Chief Justice, Honorable Judge of the Guwahati High Court, senior members of the bar. Sorry, I missed Mr. Diganto, last Advocate General Mizoram. They're all good friends here. And I went to that place also. I said that I've been here, sitting here, more than 40 years, one month. Love this place. This gives me immensely. I've studied law from JP Law College, Guwahati, and my enrollment is on Sugar also in something. Is still with the Bar Council of Assam. So any invitation from Bar Council or Guwahati High Court, I can't afford. But I have always initiated disciplinary proceedings against me, and my enrollment goes. So this is another reason I have to come here when we are called. And another reason is this is the place where my father started, Justice Hansaria started his practice in 1961 as a lawyer. Became a judge of this court in 1971 and finally reached the best school. You also want to be as a speaker has said that I've been appearing for the Guwahati High Court in now matter at the Parliament Monument. As a counsel for last 30 years, all of them. I'm extremely grateful to Honorable Chief Justice and Justice Saikya's to invite me to deliver this talk. Now let's come to the issue of today's debate, electoral ergonomics and judicial service. Let's understand what is ergonomics. A colleague of mine suggested, I started working on it. Ergonomics is a design which is best suited for a person who uses it to improve their working environment. It's an applied science concerned with designing and arranging facilities, website dictionary I'm saying, arranging things people use so that people and things work better, they're better harmony with each other. Its aim is to get best out of the system you're working. It increases the productivity and get best output. Normally, ergonomics is used with the word chair. It's an ergonomic chair, that's what we call it. So, if you sit on an ergonomic chair, you get best posture, you can sit longer period, you can work on it, and don't get tired of it, you start enjoying it. Of course, everybody loves chairs, so that's how it starts. One gets an ergonomic chair, you never vacate it, and that's the idea behind it. It gives you best posture in which you can sit for longer duration, you can work and find. Now, when we come to electoral ergonomics, let me first say why we need electoral ergonomics and what it is. We have chosen, or the global people have chosen about democracy as the best method of governance because people govern themselves through elected representatives. And I must say, and appreciate that the Election Commission has conducted elections since 1952, when the first general election was conducted of this country under the Constitution. Simultaneously for the Parliament and all the legislative assemblies. Till the last general election of Parliament in 2019, 2021, Assam Assembly election 2020, other elections. And there has been transfer of power by the ballot and not bullet. That's very important. And that's what is needed. That's why we are called the largest democracy in the country. Now, what is electoral ergonomics? It is to design a product, design the election system by which you get the best output. Now, there are two basically stakeholders in an election: the electorate and the elected, or the candidate. The voters and the candidates, the people and the neta, and I call it the rise and rosa. Now, we see election module being prepared which suits normally the candidates, the neta, for them You find so many modules, so many people working on their projects. We know in the country, Prashanti show, he prepares election modules for the country. And the idea is only to win the election. Whatever, Sam, Dam, kuch bhi hoga, chalega. But election jitna hai. That's the idea of the electoral economics so far as candidates are concerned. Now today, we must discuss what is electoral economics so far as candidates are concerned. So far as so far as the electorate are concerned, the voters are concerned. What are they supposed to do? What is the best system should be adopted? Because I would say the first responsibility is of ours. First responsibility is of the the voters. We must choose the right people. Unless we choose the right people, we get what we deserve. That's what it is saying. So free and fair election, we have a great responsibility not to be swayed away by certain factors which are not good for the ultimate development of the country. They are the responsible lies on the electorate, on the voters, the person. But so far as that is the voters part of it. Now, there are a few issues I would like to raise before all of you. First is, you will be surprised to know that the persons who are convicted for offense, convicted for heinous offenses, even life imprisonment, can get elected themselves after 6 years of their release. We have challenged this provision in the Constitution and I am acting that amicus in that matter also. Now, I find this is very strange. A person, a peer, cannot get post, he is suspended the next day. The moment there is an allegation against you, much less a serious offense. Recently, we have seen that 11 persons have been released who were convicted for rape of Bilkis Bano, who at the 11th time was pregnant. 14 persons were killed, including a 3-year-old child. And the 11 accused persons have been released only after 11 years of imprisonment. All right, it's the government has a prerogative, court will look into it. But the question is, after 6 years, each one of them can get elected to the parliament, can get elected to the assemblies, and they can become ministers also. This is not the electoral ergonomics. This is the provision which we must be very clear about it, that such a provision cannot remain. We must raise, apart from the board deciding it, we must raise an issue. How can a provision remain? And every opposition party at the time they are in opposition say this is bad. But when they came to power, this provision has been there since 1951. Nobody wants to touch it. In fact, there was a provision which has been struck down. One of the illustrious judges of the Supreme Court was the judge of this court, Justice A.K. Patnaik, where the provision was, you are convicted for an offense. The moment you file an appeal, there is an automatic stay. Till the appeal is decided, the disqualification does not arise. He continued to be member of the House. That has been struck down by Justice Patnaik in the Thomas. Similarly, this provision, apart from, that's why the judicial intervention comes in. This provision is clearly manifestly arbitrary. If a person cannot remain a peon, if he is convicted of a small offense, but a person can make law for us, will be governed by that law. Even he is convicted by a heinous offense like murder and rape. After his release and 6 years thereafter, we have a live example here. So this is one idea where the judicial intervention is necessary. Second example, and which is very disturbing, is the criminalization of politics, again connected with that. We find more and more persons with the criminal records, criminal backgrounds, acquiring the power, are getting elected in the apex body of the sovereign country, parliament, in the apex body of the state assembly, the state legislature. And you will be surprised to know, again, there I have the data not from any personal website, from the data given by the High Courts, because in the case of Assembly Upadhyay, that I have been assisting the court, data has been called for from all the high courts. In that, we find that in 2019 Lok Sabha election, out of 539 MPs, 233 MPs have declared criminal cases against them. In Assam also, as in December 2021, they get declared even by the present Guwahati High Court. 69 cases are pending, of which 21 cases are sessions cases and 11 cases are more than 5 years old. So this data shows that more and more persons are getting elected. Why? We are electing them. We are responsible. I don't put the responsibility to anyone else. We get swayed away. We approach a person who is muscle power, who has money power. He helped us at some point of time when we vote for him. We vote on the basis of caste basis. We vote on the basis of religion, irrespective of the criminal antecedent. The main responsibility lies on us. We must think, and we must think responsibly before voting any person. Supreme Court in 2 cases has directed the political parties, the Election Commission of India, to give details of the persons of the candidate they select, to give details of the criminal cases pending against them. They are available on public domain. Yet we vote them. One of the reason is perhaps the people have lost or have been losing faith in the systems, which is not good for democracy. Otherwise, why do we elect people? We don't get good people coming for election because they say, I may lose. We get people, when more and more people having criminal background as legislators, as parliamentarians. And the data again, few data are important because anything without facts, facts has to be the foundation of any argument which we say in the court also. In December 2018, when the data was furnished by all the honorable high courts of the country, there were 41,122 cases were pending against MPs and MLAs, which include former MPs and foreign MPs. Out of which, as many as 2,324 cases were against sitting members of parliament and sitting MLAs. And in even 2,000 cases, the charges were not free. This is the alarming situation. For 2,000 cases for 5 years, 10 years, charges are not even free. Supreme Court gave series of directions, appoint public prosecutors, expedite trial, pulled up prosecution for producing witnesses, have video conference facilities, and with that, it is about 2,000 cases has been disposed of in a span of 2 years. But today, the number is not increased. Number has gone up from 4,122 to 4,984 as in December 21. Again, our fault. We have elected more and more people. More and more people are coming to contest election and winning elections. Let me give you one more example as to how the criminal persons are acquiring power, etc. There was one MLA from UP, 4-time MLA, from different political parties, someone from A, next time from B, one-time member of parliament. He was lost in a jail in UP. But still, he was operating from his from the jail cabin, I will say cabin, in the jails. Just like many of you may have seen Aparan movie of Vijay Devgan. Exactly, it is not a something thought of. Actually, it happened. Somehow it came in the newspaper that this thing has happened. I, in the High Court, requested the court to get a report from the state government and the High Court. State government gave a report and see what is the report. There is CCTV camera installed, but during particular time, CCTV camera is not working. Court got a CBI inquiry done. The report is pending in a sealed cover. But fortunately, that man has been transferred. The jailer, the accused was transferred out of UP to a place to Surrey or state Gujarat, and he is lying there. This is where the judicial intervention is again required. And so we have the repeated studies on criminalization of politics. The legend law minister who come from this place, Dinesh Goswami, Dinesh Dal, who fall in love and respect, made a report in 1990. And he said in that report, the role of money and muscle power in elections reflecting seriously the well-accepted democratic values. It was interrupting the process and the big criminalization of politics. The core of our electoral problem, unless corrective measures are taken, the need of the hour is less the system will collapse. And the state, an apprehension raised in 1990 is materializing. We have not taken the corrective steps. Parliament will not take it. The elected party will not take it. They want the candidates to win. Winnability is the only criteria. But there the winnability is because we vote for them. Please don't vote for them. Please have a conscious decision on that respect. Then there is the Bora committee report. There are repeated law commission reports. 170th report, 188th report, 239. Repeatedly saying that's one important thing is the law commissions have said. That if an accused person is charged with a heinous crime, a crime punishable with offense under punishable with more than 5 years, even if charges will disqualify him. But this is a proposal by the Election Commission of India also. But the Parliamentary Steering Committee says no, we cannot accept it. Otherwise, it can be misused. All right, it can be misused for a few people. Otherwise, a person having a charge with punishable with death, he is allowed to contest and win an election. And if the trials are delayed, I'll come to that aspect a little later. The trials are delayed for years and decades. So there are 10 minutes. I'll give the figures later on. There are so many cases, even in Assam, I think 20 cases are there where the trial is more than 5 years and having session trial. I'll come to make a personal request to Honorable Chief Justice. He is here and he's been kind enough to look into all these aspects. And the Supreme Court is also raising concern about it. As I said, in the Association for Democratic Rights, Supreme Court said that you give the details of the election. Same thing was said in the Vijay Survey, Justice Parliament Assembly said, upload these details. Mere visibility is not sufficient. You have to give reasons why you are selecting it. With all these, still the persons are being selected. And in the Ashwini Upadhyay case, the Supreme Court has requested all the high courts to register a suo motu case. This Honorable Court has also registered a suo motu case pending before the lordships. In that, the lordships are monitoring the trials. Please get a report, sir, from all the cases that special courts are constituted here. Now there is an order that you cannot transfer a judicial officer heading these special courts and PMLAs without the specific permission of the Supreme Court. Because what was found in many some of the cases, judicial officer has completed the trial, he's heard the argument that let's say this transferred again, the jury hearing. They have said that let the High Court monitor it, micromanagement may be High Court. Sir, please look into it. If necessary, with the now video conferences arranged to my gain privilege, esteemed privilege to assist this Honorable Court even on video conferencing. And how did it came? How did why it was because a report, extensive report was given by this court to the Supreme Court, and Supreme Court adopted that as a model. And let this High Court adopt as a model. We have 69 cases pending, and with the Honorable Chief Justice, the way active he is, his lordship is to organize this function and many other things we have been getting. Let's have the 69 cases. Many of them, I don't say that all are guilty. If they are innocent, let them be acquitted. Many of them cases would be simple 144 violation, but the number is there. Number is there set up case. There are cases which are serious, heinous, tried, if innocent, be acquitted, if guilty, be convicted. At least we have, there are 2 or 3 states, I think Nagaland or Sikkim cases where there are no criminal cases against any MP or MLA who are ex or city. That Assam is another state where there are no cases pending against MPs and MLAs, all are decided within a time, 3 months, 4 months time. And it's possible, sir. Have a day-to-day trial, and there are series of directions on this issue. Another issue which is being debated very heavily presently is regarding freebies. Supreme Court has been hearing this case. Again, I have the privilege to assist the court in this matter also. Now, what is freebies? Do we call the welfare activities as freebies? Are we saying that there should be no economic
welfare activities by the state, the right to food, right to education, are there definitely fundamental rights. People have a right that they have education, they have good quality education. And not only the rich people, children can good education, everyone should get good education. Everybody has the right to. But the question is, because when we say that taxpayers' money, of course it's a taxpayer money. If you are earning more, you have more duty to contribute. We are not living in a barter system. That the taxpayer is given X amount of money and he must be given benefit of that amount. It has to be it's a domain of the executive, complete domain of the executive. But the question is, do you have money? Are you distributing this only with elections? Distribution of color TV cannot be a welfare activity. Distribution of somebody has said even gold in some political parties. That we will, if you win, we'll give gold of extra to every woman. That's not it. But all these things have economic impact. All that we are saying, please look into the economic impact of the promises you are making. Because the existing fiscal scenario in the country is very, very grave, sir. Mr. Dr. N.K. Singh, who is the chairman of the 15th Finance Commission, the present Finance Commission, last Finance Commission, in a speech delivered in Delhi School of Economics, has said recently, and I quote, economics of freebies is invariably wrong. The economics and politics of freebies are deeply flawed. It's a race to the bottom, and it is not the road to efficiency and prosperity. And what is importantly is saying, but a quick passport to fiscal disaster. As per the handbook published by the Reserve Bank of India, the state's debt liability today, outstanding liability, because the state also, if you generate revenue, distribute it, utilize it, the manner you do it. But you cannot borrow money and have an generational problem. You borrow money today, all right, I have won the election, next election mein dekha jayega. That's what has been happening. Today, total outstanding liability of the states as on 31st March 2021, as per RBI data, is a staggering figure of 60 lakh crore. 60 lakh crore is the outstanding liability of the states. So the states cannot borrow money at high cost from different sources and then distribute money. For example, state of UP has 6 lakh crore outstanding liabilities. Assam has 93,000 liabilities. Delhi has at least 3,600 crore liabilities. It's a smaller state. The total liability is very big. And especially the discount, the distribution, the electricity power regulatory authority has a huge liability payable by the states. Again, this has a very long-term impact on the country's development. We have seen what has happened in Sri Lanka. Petrol is not available. You have to have 2 kilometers to get petrol in Sri Lanka. Gas cylinders are not available. 3,000, 4,000. I was seeing some television in our other neighboring country, 200 to 300 kilos of potatoes. These are all fiscal problems. So one has to address these fiscal problems. The political parties won't do it. No political parties will do it. And they are not saying the courts will decide what executive domain is, what should be given, what should not be given. But they all that we are saying that there has to be fiscal discipline. You must have an economic impact assessment of whatever you are promising. As an informed citizen, I'm entitled to know when you make an election. That's what we are saying, and that I want to tell the office gathering present here. Just like that, we are giving the court has directed the criminal records of the persons to be given. When you announce any welfare activities, have financial implication, give the number of beneficiaries, who are the beneficiaries, what is the impact, and how do you propose to generate the fund? Do you propose to borrow money? People have a right to get informed decisions. And that is the judicial intervention is required. The presidency, the last Chief Justice of India, has heard this matter. I had this matter 3 or 4 occasions. There has been huge political approach among various political parties saying that this political party. We have said that almost, as I given you figure, almost all political parties announced because they want to win election. As I say, which we over election is now. But we have to think from the country's point of view. To the biggest economic institutions of this country, the Finance Commission of India, the Reserve Bank of India has raised concern, and that concern cannot be taken lightly. That concern has to be taken very seriously. Let's not go to the debt trade. So that tomorrow, today's generation all right, win election, but the next generation, as we have, who have developed this theory of sustainable development. It is not in the state report. When there is a concept of environment is concerned, we need trees, but we cannot cut all the trees today. So in the concept of sustainable development. Similarly, you have a sustainable economy. Have an economic impact assessment. Who says the course doesn't say that you stop giving distribution of the goods or the welfare meter you wish to take. You can take whatever welfare meter, but have a discipline. Without discipline, nothing works. Even in courts we find judges are little not very strict. We want to do whatever, we are not ready. But we know the judges are not going to take, not going to adjourn, not going to, I will take this, you go prepare. That's how it is. Have a discipline on that matter. And minimum, that's what I say. When they announce the election manifesto, please include on a small format. What is the policy? Who are the beneficiaries? What is the number of beneficiaries? You cannot go and say that all that you will give 10 lakh rupees to each account holder. Will give collect the election to everyone. It's very easy to say I win election, but you must have responsibility. The Supreme Court in Subramanian Balaji has said that the court said court withholding its hand at that point of time in 1993, 2013, and said the Election Commission of India, which is the constitutional body to conduct election, frames a guideline for model code of conduct for the election manifesto of this regard. And the Election Commission of India, in compliance with their direction of the Supreme Court, framed a model code of conduct, and it says the election manifesto, again I quote, which is in the model code of conduct, election manifesto must reflect the rationale for the promises and broadly indicate the ways and means to meet the financial requirement for it. And it stopped there. Election Commission has taken a stand in the Supreme Court. We have said this, but we have no power. Thereafter, we said you cannot have a model code of conduct and not enforce it. You have to enforce it. And if you don't have the power, the Election Commission has on affidavit said we don't have the power to enforce it. We cannot derecognize political parties on this aspect. That's where we have again agitated the issue, and judicial intervention is called for. And the matter is now referred to the 3-judge bench of the Supreme Court. And the reference order says the certain preliminary issues to be deliberated in second. And there are what is the scope of judicial intervention with respect to the relief sought in the present batch of petitions? Whether any enforceable order can be passed by this court in this petition, and whether the appointment of a commission and expert body would serve any purpose in the matter. Additionally, what is the scope of commission and power of it? Because one of the reasons we say, I'm not saying that you stop the political parties, at least there must be some debate, some healthy debate, economics of the country, the leading economics of the country, like Finance Commission, Commission. So Reserve Bank of India must sit together and frame some issues that there be debate at least. We talk so much of basis of caste or religion in the politics, we don't talk of economics, which is very important. Otherwise, it must fall in that trap. Sri Lanka is a living example of that. Nothing else has happened. Take money from whatever source it comes. That's why we have money lenders act. You can't take money and make get rid of my house. It's something like that. I would like to feed as many people as I want, but I have a capacity. If I can cook for 50%, I can serve 50%. If I cook for 50%, I have means to cook for 50%. I can't take loan today and serve 100% because I want to acquire power. And tomorrow I call it that when my house is full. That's where the problem is. That's why some economists, some expert body must come and put their head together, especially when they have expressed serious concern about it. So that's where the electoral ergonomics comes. Let us have an ergonomic election for the people. That's not got only an election for the candidates. That's where, as we ask for credentials, of the political parties at the time of election. Let's have on other issues also. Let's decide that we will not vote for anyone who comes with criminal records. Let's not go to the political parties who are announcing certain freebies or whatever political leaders which we know and we have seen. All political parties, not one, I'm not thinking irrespective of any whichever political party, national party, state party, everyone at the time of election they will assure you anything. And because they want vote, and we got swayed. They want our vote, we got swayed. So let's take a decision that yes, we will have conscious decision at that point of time, and that's how the economics of or economics of election will work. That's how we'll progress further. And that's where I want to stop myself and thank you very much. I really feel privileged from bottom of my heart to be amongst all of you. And I sincerely appreciate and acknowledge and feel privileged by the Indian government Assam to give me this opportunity to be amongst all of you. Thank you very much. And I want to tell you one more thing. I've deliberately, I have a pocket, in the pocket also, I have some notes of mine. But I'm using this iPad. Please start using technology. Please you start. Yesterday, I left at 1 o'clock on reviewing a matter report. Justice Chandra, who is the head of the key committee of the Supreme Court and modernizing these facilities. Some of us were using the paper. I also using the paper. He said, Mr. Chandra, you cannot use. We do not allow you to use. You have to come to the digital. So please start digitally. Many of the judges, they just don't accept. They say we have to have scanned copies, otherwise we will not be able. Yesterday I was saying many of us are hesitant, but then no, you have to get along with it. So that's why I'm deliberately prepared. I am also a learner of this. Myself, my junior colleagues are teaching me. I'm taking classes from them, I'm taking tutorials from them. There's no harm in learning from anyone. We all learn, every day we learn. So this is another thing which, especially the younger members of the bar, I must say that you must learn this. How much ILS knowledge should be, how to make people eco-friendly, how to make it digitally friendly. Please just take a look into this, and there will be a person to help us. I want to be the right person to deal there. Thank you very much, sir. Thank you so much.
Thank you, sir. In fact, that was very informative. Personal note, I would have said that we could have continued for another 1 hour, but time is very limited. Thank you so much, sir. Now I will call upon Secretary, Indian Law Institute, Hansaria, Mr. Vijay, Senior Advocate, to deliver the vote of thanks.
Honorable Chief Justice of Guwahati High Court, the President of ILA Assembly, the respected Chief Justice Mr. Vijay Hansaria, Senior Supreme Court of India, Honorable Mr. Justice Mamita Setia, the Executive ILA Assembly, other Honorable Justice of Dishonorable Court, Advocate General Assam, Advocate General Mizoram, Mr. officers, members of the Ministry, President Guwahati High Court Bar Association and other member present, President Guwahati High Court Advocate Association and other member present, Vice Chancellor National Law University, Principal of various law colleges, Law colleges, ladies and gentlemen present here today. I, on behalf of ILA Assembly, first of all, want to extend my sincere thanks to the Honorable Chief Justice of Guwahati High Court for taking active initiative to hold such beautiful program. As you are all aware, the activities of ILA Assembly has been affected for last couple of years due to COVID pandemic. But your Lordship has not only led us from the home, the President of ILA Assembly, but also took a proactive role for revamping the union facility for which we could able to hear such a thought-provoking lecture today. Indeed, this is the first program of ILA Assembly after COVID pandemic. We are very much thankful to our Chief Justice for our able guidance and make the program successful. We have just listened to the powerful and thought-provoking lecture by our eminent CPS Vijay Hansaria, Senior Advocate Supreme Court of India. A renowned advocate on some of this soil spoken extensively on this topic, which gave a new way of thought all of us. We are greatly benefited from this lecture. Despite of his busy schedule, he honored our request. We are extremely grateful to him and we express our profound thanks to him. Thank you, sir, for your sharing your views with us on the topic. We also express our sincere thanks to Mr. Justice Somitra Setia, ex-judicial of ILI Assembly, for his kind cooperation and guidance. We are deeply grateful and offer our thanks to all the honorable judges of this Guwahati High Court who have taken time out of their busy schedule to test the event with their presence. We also express our sincere thanks to Advocate General Assam and Advocate General Mizoram for their kind presence. We must express our deep gratitude and thanks to the President and other members of the Guwahati High Court Bar Association as well as Guwahati High Court Advocate Association for receiving our views. Vice Chancellor of National Law University, Principal of various law colleges, and students of various law colleges made this event successful by their kind presence. We are very much thankful to all of you. Our sincere thanks to the Registrar General of Guwahati High Court, Mr. Gautam Borua, and other members of the registry, judicial officer who rendered special effort to make this program a success. Lastly, my thanks are due to all the members of ILI Assembly, Office of Association staff who have all been the great dedication to make this program a success. Thank you and thank you all. Now, I request all of you to join us for not only tea, live refreshment.